Okay, just a quick recap. I have already discussed jurisdiction over the subject matter and nature of the action. We've discussed different jurisdiction of different courts from the Supreme Court to the Sharia courts. Now, let's proceed to jurisdiction over the parties. Jurisdiction over the parties is the power of a court to render a personal judgment or to subject the parties in a particular action to the judgment and other rulings rendered in the action. Jurisdiction over the parties refers to the power of the court to make decisions that are binding on persons. Now let's go back to this illustration. The courts acquire jurisdiction over the complainants or petitioners as soon as they file their complaints or petitions. Over the persons of defendants or respondents, courts acquire jurisdiction by a valid service of summons or through their voluntary submission. Generally, a person voluntarily submits to the court's jurisdiction when he or she participates in the trial despite improper service of summons. Okay, jurisdiction over the plaintiffs or petitioners. How is this acquired? The courts acquire jurisdiction over complainants or petitioners as soon as they file their complaints or petitions. How about over the defendants or respondents? Over the persons of defendants or respondents, the courts acquire jurisdiction by a valid service of summons or through their voluntary submission. Generally, a person voluntarily submits to the court's jurisdiction when he or she participates in the trial despite improper service of summons. Let us talk about voluntary appearance. Voluntary appearance in court. Jurisdiction over the person of the defendant is acquired by his voluntary appearance in court and his submission to its authority, or by the coercive power of legal processes exerted over his person. So on this slide, the Supreme Court in the case of Philippine Commercial International Bank versus Spouses D instructs that, as a general proposition, one who seeks an affirmative relief is deemed to have submitted to the jurisdiction of the court. So what are examples of these actions considered as voluntary appearance? It is by reason of this rule that the court had occasion to declare that the filing of motions to admit answer, for additional time to file answer, for reconsideration of a default judgment, and to lift order of default with motion for reconsideration were considered voluntary submission to the court's jurisdiction. This, however, is tempered only by the concept of conditional appearance, okay? Such that if a party makes a special appearance to challenge, among others, the court's jurisdiction over his person, he cannot be considered to have submitted to its authority. Special appearance operates as an exception to the general rule on voluntary appearance. Accordingly, objections to the jurisdiction of the court over the person of the defendant must be explicitly made, that is, set forth in an unequivocal manner, okay? And failure to do so constitutes voluntary submission to the jurisdiction of the court, especially in instances where a pleading or motion seeking affirmative relief is filed and submitted to the court for resolution. The court held that we have time and again held that the filing of a motion for additional time to file answer is considered voluntary submission to the jurisdiction of the court. Why? Because it's actually seeking affirmative relief. So if the defendant knowingly does an act inconsistent with the right to object to the lack of personal jurisdiction asked to him, like voluntarily appearing in the action, he is deemed to have submitted himself to the jurisdiction of the court. Seeking an affirmative relief is inconsistent with the position that no voluntary appearance had been made, and to ask for such relief without the proper objection necessitates submission to the court's jurisdiction. Now, let us discuss the requirement of jurisdiction over the parties in actions in personam, in rem, and quasi in rem. In actions in rem, the judgment is for or against a person directly. Jurisdiction over the parties is required in actions in personam because they seek to impose personal responsibility or liability upon a person. Jurisdiction over the person is required in actions in personam or action based on a party's personal liability, as I've mentioned. So since actions in personam are directed against specific persons and seek personal judgments, it is necessary that the parties to the action are properly impleaded and duly heard or given an opportunity to be heard. With respect to the defendant, he or she must have been duly served with the summons to be considered properly impleaded. Otherwise, the proceedings in personam, including the judgment, are void. How about in actions in rem and quasi in rem? Courts need not acquire jurisdiction over parties on this basis in rem and in quasi in rem actions. Actions in rem or quasi in rem are not directed against the person based on his or her personal liability. Okay, again, jurisdiction over the person is not necessary for a court to validly try and decide actions in rem. Actions in rem are directed against the thing or property or status of a person and seek judgments with respect thereto as against the whole world. In actions in rem, the court trying the case must have jurisdiction over the res, or the thing under litigation, to validly try and decide a case. Jurisdiction over the res is acquired either by the seizure of the property under legal process, whereby it is brought into actual custody of the law, or as a result of the institution of legal proceedings, in which the power of the court is recognized and made effective. Okay, in actions in rem, summons must still be served on the defendant, but only to satisfy due process requirements. Alright, again, actions in rem are actions against the thing itself. They are binding upon the whole world. Quasi in rem actions are actions involving the status of a property over which a party has interest. Quasi in rem actions are not binding upon the whole world. They affect only the interests of particular parties. However, to satisfy the requirements of due process, jurisdiction over the parties in rem and quasi in rem actions is required. So, summons must still be served to satisfy the requirement of due process. The phrase against the thing to describe in rem actions is a metaphor. It is not the thing that is the party to an in rem action. Only legal or natural persons may be parties even in rem actions. Against the thing means that resolution of the case affects interests of others, whether direct or indirect. It also assumes that the interests in the form of rights or duties attached to the thing which is a subject matter of litigation. So in actions in rem, the procedure assumes an active vinculum over those with interests to the thing subject of litigation. Due process requires that those with interest to the thing in litigation be notified and given an opportunity to defend those interests. Courts, as guardians of constitutional rights, cannot be expected to deny persons their due process rights while at the same time be considered as acting within their jurisdiction. Okay? Due process requires that those with interest to the thing in litigation be notified and given an opportunity to defend their interests. And finally, service of summons. Regardless of the nature of the action, proper service of summons is imperative. A decision rendered without proper service of summons suffers a defect in jurisdiction. So in one case, the Supreme Court held that respondent's institution of a proceeding for annulment of petitioner's certificate of title is sufficient to vest the court with the jurisdiction over the rest. but it is not sufficient for the court to proceed with the case with authority and competence. If a defendant or respondent voluntarily appears in trial or participates in the proceedings, then it is generally construed as sufficient service of summons, or in other words, a voluntary appearance.